Ladies and gentlemen, citizens, um, numbering is very important in the written word because it provides an opportunity for the person to manage your presentation well. Justice Wakiaga, in his number 3, he makes reference to Section 89, subsection 1, and goes ahead and refers to Section 89, subsection 3 of the Criminal Procedure Code by saying the application was certified urgent and fixed for inter partes hearing, wherein the applicant submitted that under Section 89(1), a person may make a complaint in the following terms: Section 89(3) of the Criminal Procedure Code. Now, those words are in English, but I think far much below a judge. Let's read it again. The application was certified urgent and fixed for inter partes hearing, wherein the applicant submitted that under Section 89(1), a person may make a complaint in the following terms: Section 89, subsection 3, CP for Criminal Procedure Code. So Justice Wakiaga there is mixing up his English. In those days, it was important that a person taking law to have passed very well in the English language. But that statement is not proportionate to the Honorable Justice Wakiaga's status in society. Now, in the same number 3, Justice Wakiaga quotes Section 89, subsection 1 without crediting it to that section. So he does not score very highly there, because I would have expected for him to be quoting that section. He would have indicated which section he's quoting, but he doesn't. And the quote, I'd call it packing. It's like styrofoam, supposed to support his weak decision, to show that actually he had a grasp of the issues before him. But that's not the effect that this has. The next paragraph, Justice Wakiaga numbered that paragraph 5. 5. Remember the numbering so far on the left margin are 1, 2, 3, no numbering, then 5. Now 5, the 5 we have there is actually from the wording. It's actually Section 89, subsection 5 of the Criminal Procedure Code. And I read it. It says 5. When a magistrate is of the opinion that a complaint or form of charge made or presented under this section does not disclose an offence, the magistrate shall make an order refusing to admit the complaint or form of charge and shall record his reason for that order. Now, so we know that is the Criminal Procedure Code, Section 89, subsection 5. Now, this is out of context, but because the assumption is that the consumers of this stuff are stupid, never went to school, it will be enough to hoodwink the public that these are nice, cool, gathered ruling, but it is not. Why do I say that? Note that Justice Wakiaga has left out Section 89, subsection 4 of the Criminal Procedure Code. He has quoted subsection 1. He has referred to subsection 3, and he jumps to refer to subsection 5. In this case, he is hoping that this would suggest to the complainant that actually this matter could have been dismissed under subsection 5, but it was not done that. And he himself, he did not do that. So once again, we find a public officer, like the priests of old, falling back on sophistry. And ladies and gentlemen, it's very common in Kenya today that pastors, wizards, witches, they turn to mumbling and words which really do not have meaning, but they are very good for business. So we could say that Justice Wakiaga, in this case, has become a sophist. He is the literal equivalent. His is the literal equivalent of mumbling. Mumbling is when you make sounds which really do not have meaning. His is the literary equivalent of mumbling, abracadabra, hocus pocus, and mambo jumbo. Yeah. Say things. People will assume that for you, you are important in a tie and suit. What you are saying must be right. The point here is mambo jumbo, abracadabra, and hocus pocus. They are the tools of the trade for people who deal with the masses, because they know generally the masses, they are just the masses. God never meant them to all of them to be leaders, and the people we have put above them, they are too busy propagating ignorance. Yeah, let's carry on. So my point here is that Justice Wakiaga here is assuming that nobody will bother read this, but I'm here reading it and publishing it and telling him that Justice Wakiaga, this is not the place for sophistry. We are in the 21st century, and if you feel that your trade, if you feel that your stock in trade is sophistry, you could go back to the 17th century. They are backwards. They are about. You find all kinds of nice tricks. Now, so far, we are saying in Justice Wakiaga's number 3, it is like a mixture of food leftovers, which we can't throw away, but we need to eat them for ecological reasons. So what Justice Wakiaga is doing here, it's nonsense. Now, in his number 4, he says, it must be pointed out at the onset that the applicant's application is not premised on Section 88 of the Criminal Procedure Code, which provides for private prosecution. And the applicant before the court was very clear that he did not intend to prosecute privately. He submitted that once the charge has been submitted, let the same be sent to the DPP. Well, this one, it is Justice Wakiaga who is interrogating, that's the word, interrogating the applicant in court. And out of modesty, to be nice to Justice Wakiaga on his question as what was I to do with the complaint if it was signed by the Chief Magistrate, Wilbroda Juma? And I told him we could place it before the Director of Public Prosecutions. That is, those are my words. That's how I put it. And Justice Wakiaga jumped on this and he made a case, a huge case out of it. The whole case is based on that. That I said we could place it before the Office of the Director of Public Prosecutions. What was my thinking behind my saying this? One, I had considered that by law, the Office of the Director of Public Prosecutions is mandated to prosecute criminal cases in court. However, before Justice Wakiaga, the issue is not the intention of the applicant. No, the issue is the dithering by the Honorable Chief Magistrate Wilbroda Juma. That's the problem. She's lethargic, phlegmatic. She's unable to move. That is what is the issue. Before the Honorable Chief Magistrate Wilbroda Juma is not the intention of the complainant. No. And there is no law in Section 89, the whole of it, that refers to intention of the complainant. No, there is nothing like that. And for Justice Wakiaga to have made a case out of this, it was unfortunate. Because it is the reason why to date the criminal suspects named it walk free. The only reason they walk free is because Justice Wakiaga thought it is easier business. It is easier way of earning a living if he was just to dismiss the application. That's what he did. And he went on happily with his life. One day he may sprout a conscience. One day he might sprout a conscience because I suspect his conscience might be emaciated, desiccated from heavy abuse. One day, when he enjoys peace, he might sprout a conscience and he'll know that here he made a mistake and got caught by yours truly. Yes. Now, Justice Wakiaga says it must be pointed out at the outset that the applicant's application is not premised on Section 88 of the Criminal Procedure Code, which provides for private prosecution. Now, we have checked Section 88 of the Criminal Procedure Code and we found that that section does not address itself to private prosecution. Doesn't at all. Section 88 of the Criminal Procedure Code does not address itself to private prosecution. At this point, we might have to ask ourselves, how comes that a number of judges have interpreted this section as referring to private prosecution? How comes? It's a big question. It's a big question. And we have addressed it in the past. And I think being a teacher, learning is about repetition. I'm a teacher, so I know the place of repetition in learning. That's why a mother keeps telling the baby, Bab, Bab, until the baby knows that the tall man, the beard is Bab. So, ladies and gentlemen, I have to go back to section 88 and we look for this private prosecution. Now, section 88 of the Criminal Procedure Code is titled Permission to Conduct Prosecution. It says a magistrate trying a case may permit the prosecution to be conducted by any person, but no person other than a public prosecutor or other officer generally or specifically authorized by the Director of Public Prosecutions in this behalf shall be entitled to do so without permission. So here we are talking of two things. A magistrate trying a case may permit the prosecution to be conducted by any person, but no person other than a public prosecutor or other officer generally or specifically authorized by the Director of Public Prosecution in this behalf shall be entitled to do so without permission. Now, ladies and gentlemen, that part does not talk of a private prosecutor. No. But we had actually agreed that the crux of this section 88 is the word trying. The word trying. At the crux of this, the word trying. Trying here is suggesting that the procedure is past the institution of proceedings. It's past the institution of proceedings. So the first step in the institution of proceedings, which falls under section 89 of the Criminal Procedure Code. Once that is instituted, then we roll out section 88. Now, the other word, so please, let's emphasize that word trying. Trying means that the role of parties is complete in court. Trying. The role of parties is complete in court. The complainant is there and the defendant is there. That is when you can talk of trying. But for that to happen, then we must have instituted proceedings against the suspect. So we must first roll out section 89 before we roll out section 88 of the Criminal Procedure Code. If you understand it like that, then a lot of confusion that I am going to highlight in a number of cases is going to go away. Then we might ask ourselves this question, which should be answered later. How do judges get lost between section 88 and section 89? One of the causes is because they are not stakeholders in this business. They're not stakeholders. So if he dismisses your case or listens to the case, he doesn't gain or lose. In a case, he may gain by having a file settled, not cluttering his workload. So it's better business for a judge to dismiss your case than to go through the rigor of trying the case to the end and having to write mixed up rulings because That's what I'm finding a lot of that in these things. So it's better business for the judge really to dismiss the case, and as I'll be seeing later, um, it is better business when judges understand the director of public prosecution as the god of criminal justice. The god of criminal justice. Actually, ask yourself, why would the law allow a public servant to choose to prosecute a criminal case or not to prosecute it? I'll be coming to that as I discuss the Clifford Otieno case. Everybody saw what happened, that the then First Lady, and may the Lord rest her soul in eternal peace, she did do damage on live TV, and that was a crime committed. So if Mr. Citizen can turn up in court and institute a criminal case against, say, the Cabinet Secretary for Agriculture, and he relentlessly prosecutes it, that would scare government, because government does not want that. Think under what circumstances would the director of public prosecution use those powers unless it is meant to protect power. That is the case. Let's carry on with Justice Wakiaga's ruling. Justice Wakiaga, in his number 4, says the applicant before the court was very clear that it did not intend to prosecute privately. That's bullshit. That is hogwash. Justice Wakiaga, that is hogwash. I did not say that. Justice Wakiaga conveniently put words in my mouth, that he says the applicant before the court was very clear that he did not intend to prosecute privately. That's nonsense. It's hogwash. I responded to Justice Wakiaga and said, as a response to his interrogation, that we could put the signed complaint before the director of public prosecutions, not ordering him, just offering a first opportunity to take it or leave it. But actually, that would actually have been an excess of good faith on my part, because the director of public prosecutions already had all these facts. So really, by saying we could place the signed complaint before the director of public prosecutions, I was being nice to Justice Wakiaga. But like I said, the right answer should have been, the Honorable Justice Wakiaga, what I do with this complaint is none of your business. None of your business. And the point I keep repeating is that the intention of the complainant was not the matter before the Honorable Chief Magistrate we brought up. It was not the matter. It was not the issue. The issue was this: a complaint in writing is before her. There are documents enough to show that the complaint has gone through the chain from the police to the director of public prosecution. I have given them time and nothing is happening. That is what was before the Honorable Bruno. And that required imagination on the part of Justice Wakiaga, that the intention was not what was before the Chief Magistrate, Brother Juma. The intention, in quotes, before the Honorable Justice Wakiaga is a figment of his imagination. Really, it is. Because it was not an issue. Intention is not part of the law that was in question. So to raise that intention is really like he's taking a lollipop from a child. The child does not know, but he made a mistake. I was there and I knew what he was doing. So really, Justice Wakiaga is putting words in my mouth completely. I never said, Justice Wakiaga, please confirm this. It's about honor. The Honorable Justice James Wakiaga, please make this clear that I never said I did not intend to prosecute this complaint privately. I never said that. I didn't. It's you who imagined that's what I said. What I said is we could place it before the Director of Public Prosecutions and I would give him time the way I gave all the other people warming public seats time. And if he failed, then I would take it up and prosecute the case. But to Justice Wakiaga, it's unimaginable that Mr. Joe Average, like he was truly, could prosecute the case. Let's continue with discussing this non-decision. In Justice Wakiaga's number 5, he says, the issue to my mind for determination in this application, therefore, is as to whether a private citizen, without intending to prosecute privately, can present charge before the magistrate under Section 88 of the Criminal Procedure Code. Now, like I said, Justice Wakiaga has made a case out of a quip, an aside, a statement that is not central to this. It is equivalent to the complainant sneezing in court or coughing in court. You can't make a case out of that. It was a very thin point, totally irrelevant, deciding whether suspects are going to walk free or they are going to have their day in court. Justice Wakiaga. So this was petty. He says here, the issue to my mind for determination in this application, therefore, is as to whether a private citizen, without intending to prosecute privately, can present charges before the magistrate under Section 88 of the CPC. Now, what there are no charges presented in Section 88. No, the charges are not presented as Section 88. No, the charges are presented under Section 89. Yeah, that's how it is. It's as simple as that. Justice Wakiaga goes on a tangent. In his number 6, he says, Article 157.6 of the Director of Public Prosecution shall exercise state powers of the prosecution and may. The English there is out of kilter. So say Article 157.6 on the Director of Public Prosecution says he shall exercise state powers of prosecution and may A. Institute, that was the English bit, and undertake criminal proceedings against any person before any court other than a court martial in respect of any offence alleged to have been committed. B. Take over and continue any criminal proceedings commenced in any court other than a court martial that have been instituted or undertaken by another person or authority with the permission of the person or authority. instituted or taken by another person or authority with the permission of the person or the authority. C. Subject to clause 7 and 8. Discontinue at any stage before judgment is delivered and criminal proceedings instituted by the Director of Public Prosecutions or taken over by the Director of Public Prosecutions under paragraph B. Let's see. Article 157(6). The Director of Public Prosecution shall exercise state powers of prosecution and may institute and undertake criminal proceedings against any person before any court other than a court martial in respect of any offense alleged to have been committed. Take over and continue any criminal proceedings commenced in any court other than a court martial that have been instituted or undertaken by another person or authority with the permission of the person or authority. And let's discuss that a bit. Let's agree that this is nonsense. It's nonsense. It's a superfluous quote. It does not add any value to this ruling at all. This is a quote of desperation on the part of Justice James Wakiaga. He is trying to suggest that the Director of Public Prosecution is free to take over the proceedings, but he didn't. Not to mention that under these circumstances, when the Director of Public Prosecutions has been given an opportunity to institute proceedings against suspects, he cannot come over and claim to take over the proceedings. No. Not to mention, Justice Wakiaga, please get this, the Constitution is very clear that the office of the Director of Public Prosecutions could only have taken over this case if I give them permission. And if I had shown that I did not know this, they could have done it with your blessing. I know. That's how I came to understand it. That mischief could have happened in your court. Don't try sophistry with your contemporaries. Sophistry was for a time when people did not go to school and the law was not written and the Bible was not universal. Now the law is there. We read the law. We know the procedure. If you are to rape a complainant, go ahead and rape the complainant, but he knows you are raping him. There is something else that I would like to call Justice James Wakiaga's attention to. The Constitution does envisage other persons other than the Director of Public Prosecution instituting proceedings against suspects. Look at that. Take over and continue any criminal proceedings. From who? Take over and continue any criminal proceedings. From who? Not from themselves. Justice Wakiaga? Not from themselves. Because if it is the office of the Director of Public Prosecution who instituted the criminal proceedings, they cannot take over from themselves. So this statement in B take over and continue any criminal proceedings commenced in any court. Is telling us that the Constitution does envisage another person other than the Director of Public Prosecution starting proceedings against the suspect. But above all, the office of the Director of Public Prosecutions must get permission from me. If it's me who instituted it, it's my case, and that office must get permission. I want to ask all those dinos that would like to interpret Section 88 of the Criminal Procedure Code as requiring a person to apply for permission or seek leave in Section 88 of the Criminal Procedure Code. Let them know that that section, interpreted like that, is in conflict with this statement. That is Article 157, 6b. Now, in a short while, I am going to come to the discussion of the term permission and leave. I'll also bring out a case in which actually the judges move from the term used in Section 88 without permission. It goes to apply for permission and ends up as to seek leave. Sometimes you feel ashamed of having been to school with people who are expected. It's what they do. They are supposed to read CPO statements and come up with their meaning. And due to a very fertile imagination, is that the right word? An aberrant figment of their imagination, they start imagining what is not written. I'll be coming back to discuss permission and leave, two different things. Then we continue. Justice Wakiaga goes ahead and says, Article 157.10, the Director of Public Prosecution shall not require the consent of any person or authority for commencement of criminal proceedings and exercising his or her power or functions shall not be under the direction or control of any person or authority. Emphasis added. Now, this is more hogwash. This is more hogwash by Justice James Wakiaga. There is no call for this. He is hoping that by marbling, abracadabra, hocus pocus, mambo jumbo, it's going to support his weak reason for dismissing this case. But it's totally irrelevant. I never asked the court to direct anything, the Director of Public Prosecutions. I didn't. I had only said we place the signed complaint before him once it is processed through Section 89 of the Criminal Procedure Code. We are not meant to order him or direct him. Now, note the emphasis added there. Now, Justice Wakiaga, why go into this nonsense? You're adding emphasis to something that is totally irrelevant. Huh? This is what I was calling hocus pocus, abracadabra. Mambo jambo. Lile in Kiswahili ni kama kayamba hii. You go to a mganga, he plays a kayamba, and then he's jumping on one leg, and he's wearing feathers and the skin of a colobus monkey, and there are pots that are giving off vapor, strange sounds, and the whole theater and drama is supposed to convince the customer that this is what should happen, and they should leave the goat with you. Please, in the 21st century, and people can read, can reason. We are not intimidated by the law. No, so you can read. So please, let your honor be rooted in clean honor, not in mambo jumbo. Good. At that point, there's a question I want to ask, please, and I want to ask specific people. One of the people I want to ask is Mr. Hanj, the son of Yusuf Hanj. This is a family that has been at the center of Kenya. And Mr. Hanj, it's obvious that he brought up his children properly, the way we all wish our children turn out. I also want to ask this question of the Chief Justice Maraga, David Maraga. Chief Justice David Maraga, lawyer, advocate, Chief Justice of the Republic of Kenya, an elder of the Seventh-day Adventist Church. That is not very true. I would also like to ask this question of the Law Society of Kenya, because we could say like they are the stock from which we draw our judges, our magistrates, our prosecutors, and so on. And the question I want to ask, does Article 157 make the Director of Public Prosecutions the god of criminal justice? Does it? Mr. Hanji, Mr. Maraga, the President of the Law Society of Kenya, does Article 157 make the Director of Public Prosecutions the god of criminal justice? Of course, no, it doesn't. It doesn't. So, yes, it doesn't. The other question I want to ask the same people, and go public and tell us, go public and tell us, and be clearing a lot of bottlenecks in the justice system. Does Article 157 of our Constitution grant exclusive and absolute powers, exclusive and absolute powers to the Director of Public Prosecutions? The third question I want to ask the same people, this is very important. This question, I want to ask it to Chief Justice David Maraga and the Director of Public Prosecutions, Haji, and the President of the Law Society of Kenya. And I would like to include Mr. Gitofu Imanyara here, because later I'll be discussing the case, the Clifford case. And this is the crux of the question. Does the Constitution provide the Director of Public Prosecution with power, duty, and responsibility? Power, duty, and responsibility. Or does it give the Director of Public Prosecutions right? I want to get that one. Who has the right? Me, the complainant, the right to justice, or the Director of Public Prosecutions a right to prosecute? Is it possible? Let me bring it far much home. I am a teacher by training and trade. Do I have a right to teach, or do I have a responsibility to teach? Answer this question. Do I have a right to teach, or do I have a responsibility to teach? Of the clients I serve, do they have a right to be taught, or is it me who has a right to teach them? Get this very clear to your officers in court, that don't mix state power with public rights. The Director of Public Prosecution has power granted by the Constitution, has a duty and a responsibility, but does not have the right to prosecute my criminal case. Get this in the head of the judges, particularly in this case, Justice Wakiaga. Oh, and by the way, I would hesitate to say that actually Justice Wakiaga could be one of the better judges. There's telltale evidence that there's extensive rot in the system, and actually have aberrant software in our courts. Delinquent, actually, people who are really abominations standing in the holy place. So that question, I have a right to justice and therefore to prosecute my case. But the Director of Public Prosecutions has a duty and a responsibility which should be protected actually, but not to the extent that they deny me the right to justice. So Justice Wakiaga here is playing jingles. Kwa Kiswahili tunasema anacheza kayamba, and is jumping on one leg, feather sticking from his ostrich feather sticking from his ear here. So Justice Wakiaga here is suggesting that the Director of Public Prosecutions has a right over my justice. It's not possible. No. Let's continue addressing this. In Justice Wakiaga's number 7, he says, it is therefore clear that Section 89 of CPC only deals with the making of complaint and institution of proceedings, and my read on the same together with Section 88 is that it is only provided for where the private citizen wants to institute private prosecutions. I've said over and over that the application before Justice Wakiaga is not about the conduct of proceedings before the magistrate. It's about the institution of proceedings. It's about the institution of proceedings. And my plea to the judge is to honor the Honorable Chief Magistrate Brother to sign the complaint as required. That was all. And to date, she still owes me an explanation as to why she could not sign. Justice Wakiaga does not come up with a reason because there is no reason as to why Chief Magistrate Wilbrora Juma could not sign that complaint as required by law. He doesn't. So Wilbrora Juma is naked because in this context, yeah, right there, the marketplace, she's naked. Yeah, because she failed to do what the law demanded of her. This is case number 8. Says, as stated in the case of Eroli Greenfield versus AG and 2 others, petition number 2 of 2012, our judicial system is not one where a judge is granted such powers as to investigate criminal complaint. That power lies in Article 157(4) of the Constitution. Now, ladies and gentlemen, yours truly had not asked the judge to investigate anything. No. Yours truly had not asked the Chief Magistrate, Wilbrora Juma, to investigate anything. No. All she was to do was to sign the complaint and proceed in that manner, and she could dismiss the whole thing in law. But she chose not to because the law did not allow her